Item 6 from supplementary list second bill 55 of 2003.
Where is the appellant?
अभी तो थे
उनको खबर हो गई? Your file one आइए. Your file reply to the substitution.
yes both
Which all are the substitution petitions? आइए ना.
Yes, minutes. Minutes 1B 5045 minutes for the substitution of respondent number 1 and 5.
Of 25
24 minutes.
for respondent number
1 and
1 and 5. Okay. Then
And then there is one more substitution of the sole appellant, that is 5060 of 2024.
5060.
5060 of 2024 for the substitution of the appellant.
then I have not received it for the appellate.
Not received.
Sir,
Respondent number 1 died when?
any
Well, let's respondent number 1 died on respondent number 5/7/2020.
5/7/2020. How much is the delay?
Well, the delay is of in filing the
Well, since the date of the knowledge is
Not
not date of knowledge is not disclosed, there is no.
So still, date of knowledge comes under the condonation of delay part.
Yes,
How
ma'am.
much is the delay?
Well, the delay in the petition has not been stated, ma'am.
You are seeking condonation of delay also,
Yes, ma'am.
without mentioning how much is the delay.
Yes, well, there is no date specified in the application.
How much, when did respondent number 5 die?
Well, this respondent number 5 died on 23/5/2005. Oh, sorry, let's. Yes, ma'am. 23/5/2005.
Nice, sir. 2005.
only substitute for the earlier.
Letter transfer for the appellant is not ready with the dates.
Well, this
See,
is what has been
substitution
stated.
of-
This is what has been stated in the
How
application.
many are there? 2005.
But I cannot say any date.
What do you mean you cannot say any date? You are not aware about the foundational dates. कब कौन मरा सब्स्टिट्यूशन में तो जरूरी है ना.
Yes, ma'am, that's what.
किसका डेट का कौन सा डेट लिखते हैं हम? डेट लिखे
Because
हैं या
para-
नहीं लिखे?
नहीं लिखे हैं
क्या
लेकिन
लिखे?
It's well, the para 11 of my IS says 8417 that the respondent number 5, namely Sarmati Devi, alias Saraswati Devi, wife of Mahendra Prasad, died on 23/5/2005.
That is okay.
Means, but
That is the date.
yes, but if that is so, well, it is 2005. Well,
The
it's
appeal is of 2003
in 2003. Well.
during the pendency of this appeal.
Yes, well, this is what it is.
She was this respondent number 5 was respondent number 5 was party as it is in that substitution
Yes,
in the CMP.
CMP. Yes.
She appeared.
No.
Actually, she was dead.
Yes.
She did not appear. So you file CMP against a dead person. in the year 2005?
Malats,
And
without knowledge, because it was Malats, I could examine the office report. Malats, the office report says so.
What is the date of those?
Malats,
Let's may kindly have look at of 15/3/2000 9/9/2022 minutes may kindly office note. It says that it couldn't be served upon respondent.
Respondent number 4 had also expired.
Respondent number 4, yes, Malats, and the order of
8/12/2023, if your lordship will have judicial order, Malats.
After order dated 5/3/2018, the next order is 6/5/22.
8/12/2023, Malats.
There is no such order.
it says that OP the
CMP stands abated against opposite party number 4.
Which CMP? You are referring to CMP record?
Malats, it is, yes, Malats, it is in that record the details of the opposite party number 4.
This is dated
this is Malats
8/12/2023.
eight 7/23.
8/12/23.
8/12/23.
23.
CMP stood abated as against OP number 4. Correct?
Malats, if the record says so, shows, but Malats, may I state one thing?
As against OP number 4 and IA number 960 of 2020 and IA number 8694 of 2022. This is relation to substitution of
The sole appellant.
So,
both the IAs.
No,
one IA for delay condonation, one IA for substitution. Yes. 960 is the substitution.
Okay. Was this rejected as not placed?
Yes.
No liberty granted,
No.
right?
Yes, liberty was not.
So what do you have to say?
Malats. Malats, there is one thing that I would say, that since that order of restoration is not proper because of the miscommunication or non-statement of the appellant, Malats, we are ready to challenge the said order and get it corrected, Malats. First, Malats, that is my statement, it may come on. But second thing, what I would say is
Even liberty was not granted to you. You did not take any step. It is one thing to say that you have no knowledge about the debt.
Well, it's,
You have full knowledge about the debt. You did not take any steps as against OP number 4, right? You did not take any step. You did not take any step for substitution of the sole petitioner being the CMP. Now what liberty can I grant you? No.
well, we can file an application for the revive for the review
It
of
cannot
that.
revive. It just cannot revive. मेरे पास आएगा ना, उसको reject कर.
Well, it's, these are the technical
Advocate
things.
negligence का मेरे पास कोई जवाब नहीं. चलिए कोई बात नहीं.
Well, in that case, may I advance my arguments
On what?
on the point of
The entire restoration is bad. I will say it's a nullity.
well, it's
Therefore the appeal goes. Utterance.
well, it's
Yeah.
but a few moments I'll take just in
I will
order.
give you all the time.
Well, it's, I know that there has been negligence on our part as the counsel for the applicant, but well, there are a few things that I would. Well, it's, what I say is that the restoration proceeding, millets, is a sui generis proceedings, millets, which cannot be equated as the suit or an appeal, millets. Is because, millets, as the order records that the CMP stands abated against the respondent number 4, millets, there cannot be any abatement of the restoration proceedings, millets. Millets may kindly have order 23 rule 11, millets.
What does it say?
Order 22 rule 11 says order 22 talks about the death, marriage and
Insolvency of the parties. That when there is a death of the party, there has to be a substitution, and if the substitution does not take place in time, the matter shall stand abated against the defendant.
Now, this particular order records Rule 11, which says application of order to appeals.
Now, well, it's where the abatement can take place. Whether it can take place in the proceedings of restoration, well, it's, according to my limited knowledge, it says no.
Why is because it says Rule 11, application of orders to appeals. In the application of this order to appeals, so far as may be, the word plaintiff shall held to include an appellant, the word defendant, a respondent, and the word
Suit and appeal. So the abatement can only take place. So the abatement can only take place in the suit or an appeal. Now, Miles, now on the point of restoration of the order.
Under which provision of law the restoration is filed?
Yes, Miles. It is under order 9, Miles, when the
if it is by the plaintiff,
well, it is under order 9 rule 4.
You file under order 9 rule 4?
Mileage. I have filed it under order 41 rule 19. I'll come to that as well.
No, you are filed under section 151 6. You have not invoked any provision of law. You are filed under section 151 6.
Well, I'll come on to that once.
now if your lordship will see order 9 rule 9,
May I read order 9 rule?
it says a decree against plaintiff by default bars fresh suit.
Miles, order 9 says appearance of parties and consequences of non-appearance.
Rule 9.
Yes, rule 9.
Nine rule 9. Mills में
It says where a suit is wholly or partly dismissed under Rule 8, the plaintiff shall be precluded from bringing a fresh suit in respect of the same cause of action, but he may apply for an order to set the dismissal aside, and if it satisfies the court that there was a sufficient cause for his non-appearance when the suit was called on for hearing, the court shall make an order setting aside the dismissal upon such terms as to cause or otherwise as it thinks fit, and shall appoint a date for the proceeding of the suit.
Well, it's my argument towards that is, well, it's when there is a dismissed for default or non-appearance, well, it's the court only has to satisfy itself that whether there was an existence of a sufficient cause for the non-appearance or not. Well, it's the court, while restoring the said case, has recorded that it has satisfied itself that there exists a sufficient cause. Well, it's the stricto sensu of application of the substitution.
Your petition for restoration was barred by limitation.
Yes,
So there is
the
no
appearance of the.
It was
Well,
barred by
it's,
limitation.
well, it's, I understand that limitation as well, but only for the.
You think that I do not understand.
No, well, it's, I cannot dare to.
So
Well, it's,
this is what it is. How negligent you can be. This is the height of being negligence. And
well, it's
I am
the.
not inclined. I am just not inclined. I am very
Well,
upset.
Well, it's.
I am very upset. I am not inclined.
Well, it's
to
the.
get this order
Well, it's, I
aside.
can.
No, you
Well,
have
it's-
to. I will pass an order and I will repeatedly pass such orders.
Well,
Because restoration application are being decided as a matter of course. आप लोग कुछ नहीं बोलते हैं, लिमिटेशन पर नोटिस आया नहीं आया, अपीयर हुआ नहीं हुआ, मर गया जीत गया, कुछ भी आप लोग का रिस्पांसिबिलिटी नहीं है. You have had an order of restoration knowing fully well that the appellant had already expired. कैसे हो?
Well, it's, I.
Now you listen to the order. I have given you enough audience और इतना इससे ज़्यादा नहीं दे सकते. लिखो. आगे नंबर 5045 or 24 has been filed for substitution of respondent number 1 and 5 who are said to have expired as back as on 5/7/2020 and 23/5/2005 respectively. A prayer in the petition has also been made for setting aside abatement and condonation of delay. Prayer भी है कि नहीं है?
A separate I.
Okay. A separate IA इसमें मत लीजिएगा. A separate IA number 5060/24 has been filed for setting aside abatement and for condonation of delay in filing the
8417.
8416.
5060 is for the substitution of the appellant.
अच्छा. Separate IA has been filed being IA number
8417.
8417 of 24
Yes.
for condonation of delay and setting aside substitution. Further, IA number 5060 of 2024 has been filed for substitution of the appellant, who is said to have expired on
8 sole appellant has died on
8/11/2018.
8/11/2018, and IA number, another IA for delay.
Another IA for delay is the delay is for 8. The delay is the second one is for 5045 is for the substitution of respondent number 1 and 5. For that
delay
correct.
बताइए ना इसका. IA का 5060 का delay petition.
5060 का delay है is
8417.
IA number
Delay and the setting aside of the abatement. Well, may I clarify?
अरे भाई IA number 5045 का 8417 बोले ना.
Yes, 8416.
And what about IA number 5060?
8416.
IA number 8416 of 24 has been filed for condonation of delay in filing the substitution of the sole appellant. ठीक है, ये सही है? Correct? The learned counsel for the appellant has submitted that the second appeal was dismissed for default on
31/3/2018.
31/3/2018, and a petition for restoration was filed through CMP number 302 of 2018 on 9/7/2018.
Five seven 2018 minutes में check.
9/7/2018. ये institution 9/7/2018. The Learned Council has submitted that ultimately the appeal was restored by order dated 15th of March 2024, and thereafter the prayer for substitution has been made in the present case. The Learned Council submits that since the appeal stood dismissed for default, there has been delay in filing the Learned Council for the respondents has vehemently opposed the prayer and has submitted that the sole appellant, who was the sole petitioner in CMP number 302 of 2018, had expired during the pendency of the CMP, and the respondent number 1 had also expired during the pendency on 5/7/2020, and so far as respondent number 5 is concerned, he had expired much prior to filing of the petition for restoration, that is, he had expired on 23/5/2005.
During the pendency.
I am representing only respondent number 1.
That's right, लेकिन facts तो यही
Yes, that's evidently from the idea of the
Yes.
appellant.
He submits that this is apparent from the interlocutory application filed by the appellant. The Learned Council has further submitted that the petition for restoration was filed. Not any fresh petition was filed. Yes, not any fresh petition was filed. He has also submitted that by the same order it was recorded that the CMP had abated as against opposite party number 4, but no petition for substitution was filed in the CMP, and in the present proceedings also, no petition for substitution of opposite respondent number 4 has been filed. इस वक्त यहाँ भी नहीं
नहीं,
filed
यहाँ
की?
तो नहीं, यहाँ नहीं.
ठीक है? The Learned Council submits that the order restoring the second appeal itself is a nullity, as the sole petitioner in CMP had expired and there were dead persons in the record in the CMP, and therefore,
And respondent number 1 also that.
that's it, we have already stated
Yes.
so.
Okay.
And therefore, the petition seeking substitution may not be allowed. We have submitted that for all practical purposes, the second appeal cannot be treated as restored, as the order of CMP is a nullity. Yeah. To this, the Learned Council for the appellant has submitted that even if dead persons were in the record of CMP number 302 of 2018, the same has no bearing in the matter inasmuch as and has referred to Order 22 of CPC to submit that the provision apply only with respect to orders to appeals arising out of suit and the suit.
With respect
The
to
petition for restoration is not covered and is filed under Order 9.
Melissa, I said that the abatement can only be of a suit and an appeal. There cannot be an abatement of
The
these.
Learned Counsel submits that the abatement can be only of a suit and an appeal, and there cannot be any abatement
of the
of the petition seeking restoration of a case dismissed for default.
Yeah.
He submits that the petition seeking restoration of a case could have been filed under the provisions of Order 9.
Rule 9.
Order 9, Rule 9. That's all.
Order 9, Rule 9, and I say that the court only has to satisfy itself, and there cannot be a stricto sensu following of the
The
CPC.
Learned Counsel has submitted that it is the court has to be satisfied with the reasons of dismissal of the case for default, and therefore the same is sufficient to restore the second appeal.
However, at the same time, the section 141 is the counter to that. That was this for the sake of art. This may not be written on units.
I will not write it.
The explanation says that Order 9 would be
After hearing the Learned Counsel for the parties, this court finds that it is not in dispute that the CMP number 302 of 2018 was decided when the sole petitioner had expired and the respondent number 1 had also expired and the respondent number 5 had expired way back in 2005, but still he was retained in the CMP. It is further not in dispute that an order was passed in CMP that the proceeding had abated as against respondent number 4. The fact remains that prayer for substitution of the sole appellant, who was the sole petitioner before the CMP, was made through interlocutory application, but the same was dismissed as withdrawn. And no liberty was reserved or granted to the sole petitioner to file any fresh application, nor any such fresh application was filed. In the CMP, no petition for substitution of respondent number 1 was ever filed. Consequently, the CMP was allowed, in which the sole petitioner had already expired and the 2 respondents had died, one prior to filing of the CMP
during the pendency of the appeal.
during the pendency of the second appeal, and the other during the pendency of CMP. This court is of the view that once a second appeal is dismissed, valuable right accrue in favor of the respondents, and the restoration and the provisions of substitution and the consequence of not taking appropriate steps for substitution applies in the petition seeking restoration. Since admittedly the order of restoration has been passed when the sole petitioner had already expired, there can be no doubt that the order of restoration is a nullity in the eyes of law. Section 141 of Civil Procedure Code provides that the procedure provided in the code regarding all suits shall be followed as far as may be applicable in all proceedings in any court of civil jurisdiction, and the proceedings include the proceedings under Order 9 but does not include any proceeding under Article 226 of the Constitution of India. There's the argument of the appellant that Order 22 would not apply to a proceeding in CMP is rejected.
Yes.
Is rejected. Consequently, the petition seeking substitution being INM, all the petition seeking substitution are also dismissed, as in the eyes of law, the second appeal itself does not stand restored, as the order of restoration itself is a nullity in the eyes of law.
Let me record that I have sought for time for reviving this report. May can.
तो ना हम बाबा भी जानिए आपको क्या करना है. All IA dismiss. The second appeal is also dismissed. Second appeal is also dismissed. There will be certain corrections in the order because I have to see the records once again.
There may not be against anything.
Sorry.
Well, I only stated what was there on record minutes. There may not be anything against the lawyer.
No, there is nothing
No.
against the lawyer. What I had seen.
Gross negligence.
I recorded the
No.
sentence. It is the negligence of the party. It is always attributable to the party.
Yes.
You see?
Well,
I have nothing against the lawyer. You are a good counsel. You have stated, you have yourself pointed out the provision. So I am very happy about it. And
Well, I only had to assist your lordship, but at the same time I have to show your lordship in order to assist.
One judgment for amendment. May taken in.
the learned counsel for the respondent has relied upon the judgment passed by the Honorable Supreme Court reported in 2017-13 SCC 414. कोई एक particular para है?
हाँ.
मार्क कर लीजिए.
देख.
मार्क करके वापस ले लीजिए. और ये सब बता.
Let's see, मेरा भी may I point out the paragraphs?
I was relying on 5, 6.
Of your
5
judgment
to
that
9.
you had cited.
Yesterday.
जो आपने दिया.
Yes.
पैरा नंबर
5 to 9.
ये जो मोटा वाला जजमेंट है इनका पैरा 5 to
2016,
607.
2016
1 SCC
1 SCC
607.
607. ये एक मोटा वाला था ना प्रिंट हाँ इस ये है अच्छा 2016 ये कौन है अच्छा there is one judgment which I signed 2010-8 SCC 6.
Even I could not find any minutes yesterday.
From supplementary list for hearing under the 41 rule 11 item 14 second appeal 218 of 2023.
Yes, yes.
This is plaintiff's second appeal against the judgment of affirmance. Suit filed by the plaintiff for declaration of the title and possession as well as some other reliefs in relation to some document of interest from the defendant were also sought. Now, the plaintiff has purchased the suit property from one Kishori Bank.
Kishori Bank.
Yes. In the year 1980. (21 8 1980). Now, defendants against whom suit has been instituted, they have purchased the suit property by registered deed of sale dated 29 5 1982.
29.
5 1982. From Murari Lal.
Who is Murali?
Now I will explain. Now, my lord, Murari Lal was the adopted son. Our case is that he was not validly adopted, but now, my lord, this issue should not be raised. Rather, I must say that Murari Lal was adopted son of one Seval Ram. My lord, Seval Ram, the property, suit property and other properties were jointly owned by two persons, Bansidhar Seth and Seval Ram. They were full brothers. Bansidhar and Seval Ram. Seval Ram died, leaving behind his wife Ganga Devi and three daughters. Now, this Seval Ram has also one adopted son because on the record there is the registered document which show that Seval Ram has also adopted one son, Murari Lal. His name is Murari Lal. So, meaning thereby
What is the
Seval.
date of adoption?
My lord, date of adoption it is not clear, my lord.
Exhibit A.
Exhibit A is
Deed, it's a deed of partition, not
deed of partition.
Yes.
Deed of partition.
Anyways, whatever. it
Yes,
is.
yes. Because in the year I will come, my lord. In the year 1954, my lord, there was a suit before the Kolkata High Court, wherein this wife of Seval Ram, Ganga Devi, on one hand, Ganga Devi and Murari Lal, both filed a suit for maintenance against Bansidhar Seth.
Why would Bansidhar maintain it?
Because the property, this is the admitted case, that the property was jointly owned by both brothers, Bansidhar Seth and Seval Ram. Now, Seval Ram died during the lifetime of these persons. Now, in the year prior to 1937, there was right of maintenance, as at the time of now before enactment of 1956. So it was construed that wife has a limited right of maintenance. So in the year 1954, suit was filed for maintenance, where wife of Seval Ram and the said adopted son was on the one hand, and on this was suit was filed against Bansidhar. Bansidhar also died, leaving behind Shivbai and Pannal.
अभी तक ये कहानी किशोरी लाल बाई तक
आ जाएगा, आ जाएगा। ये किशोरी जो सेवल राम की 3 डॉक्टर और हैं, चांदबाई, ताराबाई और किशोरी बाई। चांदबाई, ताराबाई, किशोरी बाई।
आपने सिर्फ किशोरी बाई से खरीदी?
मैंने किशोरी बाई से परचेज की और उन लोगों ने परचेज किया डिफेंडेंट से मुरारी लाल ने।
डॉक्टर सन से।
यस।
1982 में उन्होंने खरीदा और आपकी किशोरी बाई से 1980
में। Now there was a maintenance suit जो मैंने आप my lord just I have stated maintenance suit number 1300 of 1954. This document is on the record. In that suit, my lord, the right of the defendant, the plaintiff, means wife of Seval was acknowledged and the suit was compromised. Now this is the exhibit A what my lord was referring. Exhibit A. Now there was a compromise and a partition in the name of a partition deed. One registered document was executed on 6/6/1966.
Partition deed and compromise deed are one and the same.
On the same, because maintenance suit was disposed of in terms of that.
Exhibit A.
A. Meaning thereby prior to 1956.
This is exhibit A dated.
Exhibit A dated 6/6. Exhibit का डेट तो नहीं पता हमारा. Exhibit A जो है वो
Compromise का.
वो 6/6/1966. So this is exactly. So exactly this is the case. So in the year 1954, only right of maintenance was claimed. Thereafter, in the meantime, 1956, Hindu Succession Act has been enacted. Now looking into these facts, the right of wife not being a limited right under section 14, their right were acknowledged, and in that maintenance suit, a registered document was executed between the parties because daughters were not parties in that suit, wherein the suit land and other properties have been partitioned.
And nothing given to the daughter.
Nothing given as to. So if this document exhibit A is being considered of the year 1966, daughter will certainly have a right.
But nothing was given to the daughter.
No, but in the year 1966, any document has been created negating.
Created.
Registered. Created between the parties.
Document was it challenged?
नहीं challenge हम भी challenge नहीं हुआ. वही हम कह रहा है
She is not even a party to that.
She was not a party.
They are not party.
Yes, so that's why she was not a party. Now, in the year 1966, after enactment, by virtue of right of Seval Ram, my lord has taken note of it. सेवल राम की प्रॉपर्टी में शेयर को रिकॉग्नाइज किया गया, गंगा देवी उनकी वाइफ को, उनके डॉक्टर सन 66 में. Now meaning thereby in the year 1966 right of daughters has been negated by any proceeding, by any document, whatever it may be. Now since in the year 1966 right of the daughter was already crystallized.
No. In
Yes.
the year 1966, right of the daughter was not crystallized
Not
because she was
crystallized.
not a party to that proceeding.
No.
That proceeding.
That no crystallized by virtue of law.
Yes.
By virtue of law, what I am saying, my lord, that's why my lord, just I am just relating the dates In the year 1954, only maintenance suit was filed against.
So what is your question of?
Yes. So my question of law.
What was the suit for? Partition. Suit was for what?
Suit was for declaration of title of the plaintiffs who have purchased the suit property from Kishori Devi.
Entire property was purchased or only an undivided portion was purchased?
The entire portion of those property has been purchased. Portion.
From where do I get this?
From my lord, because this deed exhibit A is there because their case is that these properties have been allotted to Mugarila. It consists several properties. So that's why my lord, what my submission.
When were the daughters born?
They were present there. In the year 1966, because their case of that thereafter oral memorandum of partition was executed subsequent to 1966.
When? And it was amongst the daughters also?
Amongst one of the daughters,
Who?
this Kishori Devi.
She was there?
She was there, other daughters were there. This.
No, therefore in the oral memorandum
I
of
only take
partition, what happened?
kindly take the pleadings, my lord.
What happened in the oral memorandum of partition?
This suit plot has been allotted to the Kishori Devi. Now I will not argue on the
Any
fact.
mutation in favor of?
Yes. Mutation is there. Mutation case number is there, my lord. Mutation case number. It has been exhibited also in favor of this person. Rather mutation of the defendants were subsequent thereto. Now what my submission is, my lord, that even case of the party has been defendant has been taken into consideration on the basis of 9/6/1966. My rights have been said to be that doctors had no right, and both the court has given finding that no, Seval Ram died in the year 1926, and there was both the courts stated that since Seval Ram died in the year 1966.
1926.
I'm sorry. 1926. There is both the finding of both the courts that in the year 1954 there was a suit between where doctors were not party in the year 1954, and there is a finding by both the courts that in the year 1966 a partition deed was executed between Murarilal and his mother, depriving the doctors from this share of the property. Now, even if it is assumed, this finding cannot be given that doctors had no share in the property.
What is your substantial question?
Substantial question of property.
Has the court dismissed the suit or the appeal on any technical ground?
Other grounds have been dismissed.
Limitation,
नहीं
specific relief?
नहीं उस पे
उस पे
लेकिन
नहीं।
इस पे किए कि आप जो एडॉप्शन को हम चैलेंज किए और पार्टीशन डीड को चैलेंज किए उसके ग्राउंड पे भी मेरा सूट डिसमिस हुआ, लेकिन उससे कोई मतलब नहीं है प्लेंटिफ को. प्लेंटिफ मस्ट मतलब जस्ट आई एम प्रेसिंग ओनली प्लेंटिफ टाइटल ऑन द बेसिस ऑफ देयर रजिस्टर्ड डॉक्यूमेंट which they have purchased from one of the two. And just question extension question of law, that's why my only section 14 which has been affirmed by the Honorable Apex Court in Vinita Saran case.
Just a moment. You read para 19 of the trial court judgment.
Right. That it is admitted case of the parties. If my lord will allow me, can I read you from admitted case of the parties?
You para 19.
Well, when I analyze the pleading, evidence, oral and documentary as well as argument of parties mixing into admitted facts of the case, I find that Seval Ram died in the year 1926, intestate in jointness, leaving behind his widow and 3 daughters. On that time, Bansidhar Seth became the absolute owner of the joint property as per law of survivor. In the year 1926, there was no right of inheritance and succession to the female member of the joint family married. As such, widow and daughter has no right to inherit the property. Thus, neither Ganga Devi nor Ishwari Devi had any right, title, interest, or possession over the lands left by Seval Ram. It was only Bansidhar Seth, the full blood brother of Seval Ram, who inherited the properties. I further find that meanwhile, in the year 1937, the Hindu Women's Right to Property Act came in force, and by this act, widow has given limited right. In this case, Ganga Devi had brought a maintenance suit before the Honorable Calcutta High Court, white suit number 1300 of 1954. The said suit was decided on the basis of out of court settlement, resulting Ganga Devi and her adopted son Murari Lal one side and widow of Bansidhar Seth and adopted son Panna Lal other side entered into a registered deed of partition by Exhibit A. According to the said partition, half share of the properties, including the suit land, fallen in the share of Ganga Devi and Murari Lal, the adopted son. During the pendency of the suit, pleader commissioner was also appointed to make report. Since the matter of adoption was challenged by the plaintiff, but I find that Ishwari Devi, the vendor of the plaintiff, never made any objection or filed any case with respect to the said adoption. Since deed of partition 6/6/1966 is a registered document and it is also admitted by the plaintiff, therefore it is a valid piece of evidence which proves that Ganga Devi and Murari Lal became the owner, having right, title, interest and possession over the suit land, including the other land. It is the case of the plaintiff that Murari Lal had been adopted in the year 1944, while Seval Ram died in the year 1926. And as such, there is no express consent of the husband of the Ganga Devi. Therefore,
Substantive question of law.
my lord, only section 14, my lord.
One sir.
Section 14, my lord. Whether the court of
हाँ बनाना है.
Roman 3, my lord. Says, my lord, any property possessed by a female Hindu, whether acquired before or after the commencement of this act, shall be held by it as her own.
The adoption has been held to be invalid.
Valid.
नहीं? अच्छा, I am not in agreement.
Yes. वो तो चैलेंज करना भी नहीं चाहिए, वो मतलब दैट इज नॉट एन इशू. हम एक सिस्टर से परचेज कर रहे हैं, अगर ऐसे भी अगर एक एस्पेक्ट और है कि गंगा देवी मदर है, मदर प्रॉपर्टी इनहेरिट की है, बेटी को तो राइट ऐसे 66 में तो डॉटर को तो राइट था ही.
ये भी पढ़ने गलत है. That adoption is not valid. ये वाला जो पढ़नी है.
मैं पे उतना
Because there is a judgment which says that if a widow adopts, then also it will be deemed that her husband is a.
हम इस पॉइंट से
देखें कि नहीं देखें.
हम इस पॉइंट से नहीं सोच पाए. I must admit.
He gets into the family of the husband also.
हम इस पॉइंट से नहीं सोच पाए, इतना पुराना डील है.
क्योंकि इसी ग्राउंड पे खाली इसको किया है.
जी.
That the Murari Lal had been adopted in the year 1944 by Savalram died in the year 1926.
एग्जिबिट 6 जो किया है वो उसका कॉपी है, हम लोग एग्जिबिट जो 6 करा है उसमें उसमें कलकत्ता हाई कोर्ट बोली कि नहीं ये एडॉप्शन वाला इशू हम नहीं डिसाइड कर रहे हैं कि वैलिड है कि नहीं. एग्जिबिट 6 इज देयर. एग्जिबिट 6 इज देयर.
देखिए, second appeal number 218 of 2023 heard the learned counsel for the applicant. The learned counsel submits that plaintiff had purchased a property from one Kishori Bai by registered deed of sale dated 21/8/1980, and the defendant had purchased the same property from Murari Lal by registered deed of sale dated 29/5/1982. Murari Lal was the adopted son of Seval Ram. He submits that the suit property stood recorded in the name of two full brothers, namely Bansidhar Seth and Seval Ram. Seval Ram died way back in the year 1926, leaving behind his widow Ganga Devi and 3 daughters. And Seval Ram, and after the death of Seval Ram, Ganga Devi had adopted Murari Lal as her son way back in the year 1944. Adoption deed was challenged.
हाँ चैलेंज. एडॉप्शन ही चले, एडॉप्शन डीड क्योंकि वो तो है नहीं, एडॉप्शन हैज बीन चैलेंज. माय लॉर्ड इज करेक्ट बिकॉज अगर 1926 से देखते हैं, आई एम ड्यूटी ऑफ राइट माय लॉर्ड, तो 1944 तो माय लॉर्ड 26 36 एंड इट कम्स टू अराउंड 18 इयर्स. 18 इयर्स पहले केस को दोनों को मान लिया कि कंसेंट ले लिया गया, जबकि मिनिमम जो एज है, जो एज बार है वो 15 इयर्स है. तो उसमें उसका डेथ बर्थ भी नहीं हुआ मुरारी लाल का, तो मुरारी लाल के बारे में कंसेंट कैसे हो जाएगा वो बार. माय लॉर्ड इज
Time barred भी तो होगा ना.
yes.
This challenge is also time barred.
Time but if it was a wide ab initio, if it is ab initio wide contrary to the Hindu law.
The learned counsel submits that the widow had filed a maintenance suit number 1300 of 1954 along with her adopted son Murari Lal against Bansidhar Seth, which ended in a compromise, while Exhibit A dated 6/6/1966. He submits that in the maintenance suit, the daughters of the widow were not party. The learned counsel submits that since the Hindu Succession Act 1956 had already come into force, therefore, Exhibit A would not deprive the daughters of their right. The learned counsel submits that the name of 3 daughters of Ganga Devi was Chand Devi, Kishori Devi, and Tari Devi, and Jari Devi, Tara Devi, and Tara Devi, and one of the daughters had executed sale deed in favor of the plaintiffs on 21/8/1990 with the bracket Exhibit 1. He submits that the provision of Hindu Succession Act, particularly Section 14, has not been properly appreciated by the court, and therefore a substantial question of law being framed. Considering the submissions, this appeal is admitted for final hearing on the following substantial question of law. Roman 3 को
उसमें करेक्ट मिसकंस्ट्रक्शन एग्जिबिट ए को जोड़ दिया, इसमें नेम 3 में नहीं लिखा हुआ,
क्या चीज?
मिसकंस्ट्रक्टिंग सेक्शन 14 है एज वेल एज एग्जिबिट ए मैटर गिविंग giving priority right over exhibit A, prioritize the right.
Prohibition contained in section 14 of the Indian Succession Act 1956 and misconstruing the legal effect of exhibit A while deciding the issue of title against the plaintiff. इसको ऐसे ही लिखेंगे on extraneous consideration नहीं, ठीक है? Issue notice, call for records from the concerned court. For which requisites be filed under ordinary process within a period of 1 week from today.
I am ready to madam.
Post on 25th of March.
Item 15, second appeal 211 of 2025.
The second appeal will not arising out of under order 21 to 99.
Give me the dates.
Lord,
You are the
before I start, just note the refresh my notes with the provisions of law. Order 21 to 97, Lord, there the A and B files are suit, Lord. So it is decreed A files execution case against B. In the course of execution, when we not during the course of execution, if C is in possession, prefers an objection that I am in possession, Lord, he can prefer an objection that it will be decided under 101 and decree would be passed under section rule 98. Lord, if my case is under rule 99. Lord, in my case, Lord, execution case was decreed, Lord. Execution was over.
suit was decreed.
Yes, suit was decreed.
Suit was between
Suit was decreed, Lord. Mohammed Jalil Butcher has filed eviction suit against Jalil Mistri. Lordship, I prepared a
the
list
suit
of
was
cases.
what?
Eviction suit.
Yeah.
Lord, supplementary if it on the plaint के लिए plaint and WSS will also be indexed. Lord, prepare a short list of its for Lordship's convenience. Lord, eviction
Suit was
suit.
between whom?
I filed an eviction suit.
Who was the plaintiff?
Jamil Butcher
Jamil Butcher
against Jamil Mistri.
versus Jamil
Mistri.
Mistry.
Not for eviction, Lord.
Eviction under
But default in personal necessity.
eviction under Tenancy Act.
Yes.
Okay then.
The suit was decreed in 1977.
Okay.
Thereafter, Lord, the defendant preferred an appeal.
Okay.
Lord, appeal was allowed. Decree was set aside. Thereafter, I preferred second appeal before this honorable court.
You were Jamil
I was
Butcher.
Jalil Butcher. Jalil Butcher.
Jalil Butcher. Jalil Butcher was the appellant
Appeal
in
in
second
the second appeal. But in the second appeal, my lord, matter was remanded back to the appellate court. My lord, here comes my case, my lord. In the 1985 exhibit E, my lord, the matter was remanded back. My lord, now the appeal was survived.
Jalil Butcher filed second appeal. It was matter was remanded to the appellate court.
My lord, now thereafter, my lord, this is a list of dates, my lord. My lord, it is not mine. This is an admitted list of dates of both the parties. Now, my lord, my tenant, my lord, purchased the property from someone, my lord, from Majumdars in the
Jalil
1986.
Mistry.
Jalil Mistri. Lord, he purchased the property from some Majumdars. Lord, this deed was not exhibited in that eviction suit. during the pendency of the appeal after the remand, he might didn't purchase the property from someone, and this deed was not executed, not brought on record, not seen the light, my lord, till this objection. Thereafter, my lord, the sole appellant, Jalil Mistri, my lord, he died. During the pendency of the appeal, he died. And my lord, thereafter,
He died when?
my lord, on 9/3/2001. My lord mentioned the date, my lord, also. 2021, he died. And thereafter, my lord, on 31/8/2001,
No, before the first appeal, Jalil Mistri was the
was a defendant. Well, sorry,
Was the
appellant,
appellant.
sorry, appellant. He died, sole appellant died, my lord. And thereafter, my lord, his legal heirs, my lord, transferred the property to the opposite party number 1. My lord, here the opposite respondent number 1.
so appeal awaited.
Yes, my lord. Therefore, my lord, in that thereafter when the appeal was abated, my lord, I am coming, my lord.
Appeal automatically
My
abated.
lord, yes, I am coming to that. In the 2002, I filed an execution case, and thereafter, my lord, the appeal was abated in the year 2004. There is an order, my lord, that appeal abated, my lord, 23.
Appeal will stand abated.
My lord, after
No
the
order
demise-
is required.
my lord,
The
there
law
was
is
an
well
order.
settled.
Yes.
There no order is required for
Yes,
abatement.
yes,
It
that's-
automatically abates
that's
upon
true.
expiry of 90
That's-
90 days.
That's now, my lord, I
So
filed
he died on
2001.
9/3/2001.
Yes.
Okay.
Thereafter, his legal heirs sold out the property to the respondent number 1
Appeal
during the
abated.
pendency of the appeal.
But it abated prior to expiry. 9/3/2001, it abated within 90 days. After abatement, the property was sold.
My lord, it was not within our knowledge, my lord, that no
No.
one informed, my lord. Court
Nobody
issued
might have
notice.
informed.
Court issued notice, my lord. Person
But
the remand, my lord.
The dates reveal
Yes.
that it stood abated.
Yes. Thereafter, since the matter was remanded by the Honorable High Court, my lord, the Honorable Court issued notices, and the process has been reported that he has died in some year 2001.
That's
Thereafter, my lord, the order was passed since the sole appellant has died. The suit of the entire suit appeal abates. This is Exhibit G. Now, thereafter, my lord, in the execution case, my lord, which is
Who
number.
filed the execution case? Jamil
I
Mitchell.
filed, Lord. I was Jalil Butcher. I filed an execution case. Lord, the delivery of possession was through process of court. There is 2 dates, Lord. On 6th, Lord, the possession was given by breaking open the locks, and thereafter the procedural order has been passed that possession has been delivered. Now, Lord, on 5/3/2005, Lord, the objection has been preferred under Order Rule 89, claiming that it was not a Jamil Mistri who has been dispossessed, rather I am been dispossessed. And that application was allowed, appeal dismissed. There was second. Now, my lord, one thing, Lord, Lordship may kindly consider Rule 102 for a moment. Because of Order 21, my lord, before I dwell into the fact, my lord, just flip the page list of dates, my lord. I framed a substantial question, my lord, to Lordship's perusal, my lord. And this is my question of law, my lord, which is there on the appeal memo of appeal also. Rule 102. Lord, I filed an application now under 7 Rule 11. My lord, that was not considered by the trial initial original court, my lord. And at the appellate court, my lord, since the final order has been passed.
What is the second part?
The second, my lord, I also am satisfied with the first part, my lord. And I'm coming to the second part also. Lord,
Just a
actually,
moment.
yes, my lord. If Lordship sees
Whether
102.
the court below committed a manifest error of law in omitting to hold that the transfer in favor of respondent number 1 by 2 different savings executed during pendency of title appeal number 49.
Lord, after the remand, my lord, which awaited in year 2004.
No, it abated prior to that.
Yes, yes.
It abated, it was not during the pendency of appeal.
Lord, the appeal was dismissed as abated on the 2004. This is the order.
Maybe,
Yes,
even if
Lord.
there is
It's
a
a law, my
there is
lord,
an
that
order,
yes, Lord, there is a law, my lord, that after the demise, my lord, after 120 days, the appeal automatically submitted in case
not
of
120
non-substitution.
days, 90 days.
90 days thereafter.
Then if a person files a petition for
Setting aside
setting
abatement,
aside
then
abatement, because that
I stand
petition is
corrected.
required to be filed,
Yes.
and then 120
120
days.
days. Yes,
So the appeal stood abated,
yes.
and after the abatement of appeal, the property was sold.
Yes. No, property. Yes.
Right?
Yes,
The
yes.
property was sold after abatement of
Yes.
appeal.
But I was only because mentioned that the procedural order, which is an exhibited document, also which says that the appeal abated in the 2004. Although there is a law is well settled that there is no question of abatement, specific order is not required.
Abatement.
Yes, that is true. Lordship, if Lordship may kindly see Rule 102 for a moment. Lord, once application is filed under Rule 97 or 99, Lord, adjudication has to be made under Rule 101, which says the question has to be determined by the parties. And whatever will be the situation, either 97 or 99, Lord, finding will be under Rule 99, 98 or 100, as the case may be as per the application. Now, Lord, there is an embargo under Rule 102. Mere placement.
Yes.
Rules not applicable to transferring pendentilit. Nothing in Rule 98 or 100 shall apply to resistance, obstruction in execution of a decree for the possession of movable property by a person to whom a judgment debtor has transferred the property after the institution of suit in which the decree was passed, or to the dispossession of any such person. Lord, the suit was after the decree, Lord. The suit, Lord, the property was transferred to this respondent number 1. Lord, therefore, this transfer was
not pending.
the transfer was pendently transferred. Lord,
No.
if the unsuccessful party has transferred the property, Lord, what right he has, Lord, under rule?
Unsuccessful party, the appellant was Jamil Mistry,
Yes, his heirs transferred the property.
and the case was arising out of an eviction suit,
Yes, Lord.
right? The
Yes.
case was arising out of an
Eviction
eviction suit. Eviction suit will have nothing to do with the passing of title.
Yes, Lord. But Lord, one thing is there.
Merely because a person is a tenant, there is no legal bar
But Lord,
that the property cannot be transferred.
yes, Lord. Then will not in that situation he has to file a separate suit, Lord, claiming title, my Lord. But in this execution case, my Lord, this application was not maintainable. My humble submission, my Lord, is that this application he may have preferred a separate suit, my Lord, no issue, my Lord. But in this application, my Lord, this execution, with my execution case, you are a transferee pendent in it. From the unsuccessful party, you have purchased the property.
No, he was not unsuccessful. He has purchased the property from
Jamil
Majumdar.
From Jamil Mistry, my Lord. This respondent number 1 has purchased the property from Jamil Mistry, heirs of
And
Jamil Mistry.
Jamil Mistry has purchased the property
From some
Majumdars.
Yes.
So Jalil Mistry once purchases a property from a Majumdar,
Yes.
and
Therefore, my Lord, he has
So
a
there
separate
is-
cause of action, my Lord, for them. Not here in this my execution case, my Lord. He has a separate cause of action, my Lord. He has a right, my Lord. But not in my execution case.
you see, in execution case,
Yes.
if anybody is objecting to eviction,
Yes.
or they may file, a third party has to file a petition, right?
Yes. Yes.
It is not in dispute that the third party has been dispossessed. It is not in dispute. Third party was in possession of the
Third party
property.
was not in my case, my Lord. Through the process of court, Jamil Mistry was dispossessed. There is a, my Lord, therefore, my Lord, I could file a supplementary affidavit showing my Lord the Nazir's report also, my Lord. By breaking open the locks, my Lord, the possession was delivered, my Lord.
On the spot, this person was there, no?
Lord, there is nothing on record, my Lord, as such, my Lord. There is nothing such on record, my Lord, that, Lord, the Lordship, there is a Nazir's report, there is an order of the court also, my Lord. That possession was delivered to break open the locks, then no whisper, my Lord. Lord, if suppose, my Lord, possession is being delivered, they had a right to file an application under Rule 97 also, my Lord, before delivery of possession. No, my Lord, nothing, no application was filed. Delivery of possession was done. Now, my Lord, after 1 month, my Lord, in the month of March 2005, one application has been prepared, claiming that I have been dispossessed. Lordship sees supplementary affidavit, my Lord, for a moment there is a report of a Nazir also, my Lord. I will next, my Lord, just to Assist me, Lord. But this, there is a specific finding by the trial court and the appellate court has not considered this as a point of determination. Has not also whispered Milord of 102. No, 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 says this is the core issue Milord which is required to be decided by the appellate court.
You see, 102,
Yes.
this will not apply to resistance or obstruction in execution of a decree for the possession of immovable property by a person to whom the judgment debtor has transferred the property
Yes.
after the institution of the suit.
Yes.
Here the judgment debtor has transferred the property.
Yes. The legal is a judgment letter.
No, that is a subsequent transfer.
Yes.
But this Jalil Mistri,
Mistri has
that is
transferred.
the defendant in the suit,
Yes.
he claims to have purchased the property from someone else, a
Yes.
third party,
Yes.
right?
Yes.
And then thereafter, he purchased the suit irrespective of tenancy. He purchased the suit from third party. And ultimately, when the suit was decreed and the appeal was filed, the appeal stood abated ultimately,
Yes.
right? So the order of eviction became final, right? Now this person, Jamil Mistri's
Heirs.
heirs, had sold the property to
Respondent number 1.
respondent number 1. The sale is not during pendency. The sale is not during pendency.
Even if the sale is not during pendency, that he was unsuccessful party, how can he make an application without under my execution case? He has separate cause of action.
But he was dispossessed from the property, that is why he had filed a petition.
Yes, but Lord, kindly see
Then
the
that has
Nazir's
to be
report.
decided just like a suit.
Lord, then his lordship may kindly see Nazir's report also. Lord.
So that is on merits.
Yes.
Whether this petition was maintainable or not is something we are looking at.
Yes. Lord, when he was not in, if suppose he was in possession of the property, then he has a remedy under Rule 97 before he was being dispossessed, which is not a one game show, not a 2002 execution case, Lord, 2005 I haven't delivered possession, Lord. He could have resisted, Lord, then if he would have been in possession of the property.
Merely because he did not resist at that
Then-
point of
thereafter,
time,
Lord-
post
Yes, they have
dispossession,
right.
he cannot resist.
Yes, he can. Lord,
He has done his done.
No, he has done, Lord, but Lord, he has purchased the property from an unsuccessful party, Lord, who was a defendant, Lord.
No, the unsuccessful party was not. Unsuccessful party had purchased a property from a third party.
Yes.
Yes.
Now, Lord, he has purchased from someone else, Lord, but the chain has to be seen, Lord. But in my execution case, Lord, which have allowed, this is a self-contained code, order 21, Lord. Lord, then every execution case will not complete, Lord, then. Although, Lord, Rule 101 says that all issues has to be decided. But, Lord, it is not something like a separate suit, Lord. It has to be within the periphery of that particular execution suit only. We cannot expand the, Lord, the nature, we cannot change the nature of the suit. That is, the eviction suit, Lord, and now individual rights are being claimed, Lord. And Lord, interestingly, my Lord, the property which has been purchased by the claim, he claimed the Marjum Tarif Lordship permits, I can show the document also. Lordship, the second question of law, my Lord. That property, my Lord, is located at Milord. This particular suit property Milord is located Milord at somewhere in corner plot of Dangatoli Chowk. And Milord, in the original deed of 1912, I have a copy of a deed in which Milord deed number was mentioned as 765. And now Milord in 1987, the deed which has been sold to Jamil Mistri Milord, it has been mentioned as 767/1767. Sorry. 764/1217. The property Milord originally the Majumdars belong Milord they claim. This deed in that deed Milord 1912 deed it was mentioned as 764. I can show you Lordship the deed also Milord. 764. And Milord in the 1987 Milord Jamil Mistri purchased the property. It has mentioned 764/1217.
Yes.
Milord, it cannot be Milord because Milord at that time CS Khatian was there and now Milord the MS Khatian is prepared. It could not have been. Milord, this comes under the municipal area Milord. It comes under the MS Khatian. I have annexed the village map also that is related to Konka village Milord and two different places Milord. Milord, the property which he has purchased is of the Bahu Bazar Milord. And this property, suit property is located at Dangatoli Chowk. I have annexed the village map also to Lordship. If Lordship permits, Milord, I can show Milord the map. So Lordship permits Milord. And Milord, therefore Milord.
Unequivocally show transfer of CS plot number 764 alone.
Yes. 1912 का deed में Milord 7.
And plot number 1217 is not mentioned.
No.
There was no occasion to mention it.
Milord, उसमें था ही नहीं तो कैसे बेचेंगे?
हाँ, 1217 तो 1912 में है ही.
हाँ, 1912 में Milord
It never existed.
हाँ ठीक है.
Right?
ये जो
There is a subsequent deed in 1971 में.
हाँ.
They are referring to CS plot number 764.
corresponding कर रहे हैं वो क्यों
corresponding to MS plot number
तो
1217.
corresponding दिखाएंगे ना मैडम करके मतलब correspond कर रहा प्रूफ करेंगे ना correspond कर रहा है दोनों प्लॉट corresponding है नहीं प्रूव कर पा रहे हैं वो इसी चीज का इसलिए विलेज मैप हम दिखाए विलेज मैप हम लगाए लॉटशिप परमिट्स प्लॉट हम उसको
Did you join issue on this?
यस मैम
What was the issue framed? Which issue was that?
Yes, the trial court or the appellate court?
Anyway, trial court first.
Trial. Not the page number 98. What is the issue number?
98.
98. Sorry, page number 38. Sorry, 38. Well, the first issue is issue number 4, which I try to convince me.
There is no page number 38.
I'm sorry.
There is no issue in page number.
Yeah, page number 33. Sorry, 33. We start from 32.
33, yes. Where is the dispute? Under which?
Yes.
Where is the dispute?
Yes, just. There is a finding lot of things shown here. Lordship may kindly take issue number 5, page number 42, 5, 6 and 8. The jointly it has been decided.
Don't show me that you raised objection to this. First show me that this is not corresponding to this.
But I find a WS also not in that.
Please, where is that?
Yes, the supplementary affidavit I had filed.
Page number?
Blood supplementary affidavit page number starts from 26.
Yes.
Just a minute. Blood para number 28, page number 40. May I please? That the suit property is covered under MS plot number 1217 and it never corresponds to municipal survey plot number, but it should be 764 or holding number so and so within ward number so and so. The opposite party number 27227 had no right to sell the above suit property by virtue of the registered deeds. And made a specific that does not correspond to the and there are discussions also about in
Where is the finding?
page number 42. It starts from page 42 number. Page number 48, finding starts with 51. Para number 22 onwards.
Para 18.
Variety, yes. From the discussion above and the evidence transpired that the property located adjacent to Purlia Road and Circular Road was purchased by, it should be Baba Dipendra Mohan Mukherjee through Exhibit 4. This is 1912. Thereafter, the heirs of Dipendra Mukherjee transferred the property to Jalil Mistri situated at Purlia Road, showing it as of MS plot number 1217, holding number so and so, ward number so and so, exhibit 2. This is 1987 deed. Subsequently, the said property was transferred by the heirs of Jalil Mistri to the petitioners through exhibit 1 by A. Evidence shows that with respect to the boundary of the suit property situated at Purlia Road, also there is supporting evidence to show the name of the vendor of petitioner over the plot number holding number so and so 1780. Above discussed leave no room of doubt that the property purchased by the vendor of the petitioner was not situated at Bahu Bazar area, rather it was situated at Purlia Road within the present Lalpur PS, and further portion of said property was purchased by Jalil Mistri and subsequently by the petitioner. 19. Opposite party number 1 in his pleading specifically stated a para number 24 and 25 of his show cause that pursuant to the judgment and decree passed in title eviction suit number 110 of 1973, he was declared owner. But opposite party number 1 in his cross-examination at para 64 and also opposite party number 8 in the cross-examination para 19 specifically stated a inconsistent fact from his pleading that the suit property was allotted to Jalil Richard through Ranchi Municipal Corporation on perusal of the exhibit C in para 7, last 4 lines. There is a clear observation of the court that no paper was shown with respect to the title, not the plaintiff has traced his title or said word about the mode of acquisition. In para 9, conclusion was drawn by the court that the plaintiff could not prove his title. In para 14 of the judgment, the plaintiff was shown that he has found to have proved himself to be the landlord and was granted relief, though he could not have proved his title. From the judgment, it is crystal clear that the plaintiff was never declared owner of the suit property. Moreover, that the suit was for eviction of the defendant on the ground of landlord in a relationship, and it appears from para 14 of the judgment that only on the ground the plaintiff was found as a landlord, he was given relief. In such eviction cases, question of title is not germane. Therefore, mere declaration of status of landlord cannot be said to confer title on him. Apart from that, OP number 1 has absolutely failed to produce any document regarding settlement said to have been made with Ranchi Municipal Corporation. Even no tax receipt, holding receipt is filed on behalf of consideration. Further, OP number 1 himself in para 25 of the show cause, as well as exhibit number R, it is admitted that the judgment and the decree passed activation suit number so and so becomes conclusive and binding. It is also asserted by on behalf of the party number 1 that in eviction suit number 110 of 1973 there is also a finding that the defendant could not prove the ownership of Pratima Devi. In that case, Pratima Devi was never the party in that suit. Therefore, any observation regarding title made in the suit will never be binding upon Pratima Devi or the legal heirs of Dipendra Mohan Mukherjee. Moreover, in the suit of title of Pratima Devi or the other legal heirs of Dipendra Mohan Mukherjee was never a maternal issue. And the contention has also been made on behalf of party number 1 that from the cross-examination of PW2 as well as cross-examination of PW6, it is evident that the required consideration amount was not paid to the vendor against the vending exhibit 1 and exhibit 1 by A. It is also stated exhibit 2 shows that for the transaction of sale liability of imposed upon the purchaser in case of any defect of title was found, whereas exhibit 1 and exhibit 1 by A, the liability was imposed upon the seller in case of any defect in title is found with respect to the property sold. It is stated that above transaction shows doubtfulness regarding the title of Jamil Mistri and also regarding in the title in possession of present petition.
You heard the learned counsel appearing on behalf of the applicant. By giving the foundation background of the case, the learned counsel has furnished the following statements. He submits that the petition under Order 21/99 was not maintainable. It is also submitted that the identity of the property which was covered by exhibit 1 and 1 by A was also not duly established, and the courts have misconstrued the exhibit 4 within brackets CAT dated 27/2/1912 brackets exhibit 2 CAT dated 26/6/1987 and CS map within brackets exhibit M. After hearing the learned counsel for the appellant, this appeal is admitted for final hearing on the following substantial question of law. Whether the learned courts have committed an error of law in entertaining the petition under Order 21. Rule 99 is right?
Yes.
Rule 99 of CPC. Sarvepalli case, the learned counsel has submitted that two different sale deeds dated 31/8/2000 has submitted that one sale deed dated 26/6/1987 was executed during the pendency of the appeal before the learned first appellate court pursuant to order of remand passed by the High Court dated 20/11/1985 and thereafter two sale deeds dated 31/8/2000 was executed by the purchaser of the property by exhibit 1 and 1 by A. Whether the reports have committed perversity by dealing with the identity of the property in misconstruing the exhibit 4 with the bracket sale deed dated 27/2/1912, exhibit 2 sale deed dated 26/6/1987 and CS map with the bracket exhibit M. Thus, issue notice to the respondents for the recusals. Up to Ranchi through the concerned police station be filed within a period of 1 week. Within a period of 1 week, call for the records from the concerned court. Post on 25th of February.
We also the process through courts concerned executing court proceeding if it to be served in the
At this stage, the learned counsel for the appellant has submitted that since the executing court is proceeding in the matter, liberty may be granted to the appellant to serve the notices through the advocate appearing for the respondents in the executing court.
in addition to
the mode of service as mentioned. Prayer is allowed, that's the initiation.
the execution is put up on 28th
28th.
February. The 19th was the last date, and 28th cost has been deposited. But I have the order sheet also.
Till at this count, you have filed your petition.
Yes,
for
I
stay.
filed IA for stay. Yes.
IA number?
Yes.
Sorry. 1698. 16986 of
2026.
2020.
25.
Notice also in the same regulatory application. Further proceedings in the execution case number?
Execution case number 23 of 2019.
23 of 2019. Pending before the court.
Civil Judge Junior Division 21.
Civil Judge Junior Division
21. Divya Raghav
21.
21.
Ranchi.
Ranchi.
State till हम लोग कौन सा डेट दिए 25th of
Divya
Orders item 13 takes place second April 16 of 2026.
There is no substantial question on this appeal is dismissed. Order will be uploaded by the evening. That citation is to be generated. Order will be uploaded by the evening.
For supplementary list orders item 12 first April 304 of 2023.
Of respondent. Some respondent are died.
You have died.
Respondent number 13, 54,
Item 12.
12.
Item 12 of supplementary list.
हाँ, फिर तीसरा चार हो जाता है। तीन अभी मंजूर। 13, 54 और 59।
13,
54 and 59.
54, 59. When did they die?
That 13 was 15/4/25. 15 अप्रैल 2025।
और 54,
54 में रहा है 5/1/25।
5,
1/25।
1/25 और 59
59 के डेट नहीं पता नहीं।
आपके रिलेटिव हैं? आप किसकी तरफ से आपके घर?
उपयोग कर रहा है 5 to 6, 8 to 30, 32 to 56, 58 and 59।
उनका ही कर रहे हैं, जिनका appeal कर रहे हैं, जिनका नाम बोले।
हाँ
13, 54, 59 के appeal कर रहे हैं आप।
54, 59 का वकालतनामा फाइल किया है ना?
हाँ फाइल किया।
और 13 का भी तो फाइल किया है ना?
13 का फाइल है।
आप तो लीगल हेयर्स का नाम दीजिए। अरे भाई, you file an affidavit giving the date of death, the legal years, सबका नाम देंगे तब ना सब।
ऑर्डर 22 उल्टे में दिए ना।
ठीक है तो
FA number 304 of 2023. The learned counsel for the respondent appearing for number of respondents including respondent number 13, 54 and 59 has submitted that these three respondents have expired. He prays for 2 weeks time to bring on record the name of the date of death and the name of legal heirs and successors. The needful be done by the learned counsel for the respondent by 4th of February. 2 हफ्ता हो गया ना आपका? 2 हफ्ता मांगे, 2 हफ्ता दे दिए, बस उसके बाद कहानी बंद कर दी।
ठीक।
पोस्ट ऑन 18th। तब तक आप कर देंगे फाइल?
हाँ अगर हमको डिस्क्लोज करेंगे तो अभी कर देते हैं।
फाइल
ऐसे डिस्क्लोजर
ऐसे
एरर हो जाता है।
अब फाइल करेंगे।
I'm respondent number 2 and 3 in this case. So far the respondent number 1 is concerned, my lord, the state may be directed to find the substituted notice because my lord, notice has gone but unserved, and my lord, the respondent number 1 for the clearance of respondent number 1, my lord,
अभी
State में भी
एक साथ करेंगे। अभी कौन-कौन अपीयर होंगे, कौन-कौन नहीं अपीयर होंगे?
सब
एक
appear
साथ।
हुए हैं, सब appear हुए हैं। ये जो 3 बोले
सब अपीयर हो चुके हैं।
हाँ kindly see the last order 23/10/2024 का order, kindly see 23/10/2024 का
1 and 60
One-
अपीयर हो गए हैं।
नहीं 160 जो है उनके बारे में ये आया हुआ है इसमें रिपोर्ट
एड्रेस ही शिफ्टेड।
हाँ वो जमुई में रहते हैं ये ऑर्डर आया है
With
और
respect to,
One.
as per the office note, the respondent number 1 and 60 could not be served for want of address, for want of proper address. Counsel for the appellant is granted time till the next date, either to take fresh steps for service of notice upon respondent number 1 and 60 at their present and correct address, or to file an appropriate petition seeking substituted service of notice. One died.
One is company, Dabur India Limited। उनका तो एड्रेस
One कैसे died हो जाएगा?
हाँ वही कंपनी है तो कंपनी इंडिया लिमिटेड की कंपनी तो डायरेक्ट नहीं होगा।
सिग्नेटरी है सिग्नेटरी
जो ऑथराइज्ड सिग्नेटरी है उनका
उनका
वो किधर साफ कर रहा है।
My lord, I was appearing for respondent number 4. He died on 23/9/2025.
बताइए आप ही बताइए।
आज
Respondent number 4 बताइए।
he died on 23/9/2025. Or
Respondent number 4.
yes. So I have
Counsel
to
for the
file.
respondent number 4 has submitted that he has expired on 23/9/2025. आप भी वही petition file करें।
I have to file.
Give the details of the legal years and successors. साथ में आप लोग अपना वो भी कर देंगे ना, वकालतनामा जिसका जिसका
हाँ
ये भी file
सब्स्टिट्यूट
कर
अगर मिल
दीजिएगा।
जाएगा तो हम कर देंगे।
मिल जाएगा क्या? जब आएगा बताने के लिए तो उसको बोलिए दे देंगे।
आप certainly, my lord.
ये रेस्पोंडेंट नंबर 1 नो मोर कैसे आ गया?
वही तो नहीं होना चाहिए वहाँ पे तो
The counsel for the appellant has submitted that respondent number 1 has been reported dead. He submits that respondent number 1 is Messrs. Dabur India Limited and it's a company. Even if the constituted authorized signatory has expired, the company is still existing. The counsel for the appellant is directed to take appropriate steps for fresh service of notice at the registered office of respondent number 1. Okay? Within a period of 2 weeks. तो आपको वेबसाइट में जाइए, आधा मिनट के अंदर रजिस्टर
हाँ वो देखें
डाबर इंडिया लिमिटेड का मिलेगा रजिस्टर्ड ऑफिस थ्रू स्पीड पोस्ट ऑफिस टू ट्रैक स्पीड पोस्ट
60 का भी मुझे कर दिया
60 का क्या करें
60 का भी शिफ्ट हो गई है अपने ससुराल या कहीं रिपोर्ट आया है
नहीं वो हम नहीं जानते हैं आप या तो प्रेजेंट एंड करेक्ट एड्रेस
हाँ प्रेजेंट करेक्ट एड्रेस पर रिपोर्ट हैज
तो जमुई डिस्ट्रिक्ट में अपने ससुराल में रहती है।
हाँ तो आप उनको प्रेजेंट एंड करेक्ट एड्रेस पर करेंगे नहीं तो सब्स्टिट्यूटेड सर्विस करेंगे
प्रेजेंट एंड करेक्ट एड्रेस पर उनका कर दें
तो बड़ी कंटेस्टेड केस लगता है
All are the rayers. Only the respondent number 1 has sold the property. I am the purchaser. All are the rayers. Under the land was sold.
Respondent number 1 is Dabur India.
Dabur India.
They have sold the property to
Property to me.
Well,
I am only I am the aggrieved in this case. All are the rayers. Already decided the case. My WPC number when my sale deed was not registered. I filed the WPC in this honorable court. This honorable court, by the order of this honorable court, the sale deed was registered in name of respondent number 2 and 3. और 2 and 3 के बाद जितने भी है सब रही है उन लोग का कहना है
अर्ली हियरिंग का आइए
असली हियरिंग हो ही रहा है
हियरिंग इज क्लोज्ड चलिए
इसमें एकदम कुछ नहीं लगेगा सिर्फ WPC में जो ऑर्डर है ना उसमें सारा कुछ डिसाइड
कुछ तो लगेगा अब ये फर्स्ट अपील है हियरिंग लोगों में कुछ नहीं लगेगा
LPA भी डिसमिस हो गया इनका
तू LPA
पोजीशन में ही है ना आपको
पोजीशन में हम हैं पोजीशन में ये तो सावन में जब होता है वहाँ सावन बोलबम वाला तो हमसे ही परमिशन लेते हैं कि हमको दीजिए इसमें पुलिस रखेंगे हम देते हैं इनको परमिशन लेकिन ये स्टेट गवर्नमेंट ने ये फाइल कर दे जबकि ये सिविल सूट हार चुके हैं सब कुछ हार चुके हैं LPA हार चुके हैं सब कुछ ये सब रैयत लोग हैं हम एग्री
अच्छा एक बात बताइए अगर स्टेट ये सब नहीं करेंगे आप क्या करिए
नहीं इसलिए हम बोले कि अगर डेट में ज्यादा ये लोग लिंगर करना चाह रहे हैं हमारा यही
देखिए वैल्यूएबल प्रॉपर्टी है कंटेस्ट सुप्रीम कोर्ट आप एकदम तैयार रहिए
जी जी ठीक है
कोई हारे कोई जीते अभी तो पता नहीं
कोई पता नहीं
क्लियरेंस कंप्लीट नहीं हुआ
नहीं आइए सब आइए लेकिन मेन यहाँ है बस 2 and 3 हम हैं बाकी बात इन लोग सिर्फ लिंगर कर रहे हैं
आपका पार्टी वीडियो देख रहा है क्या आपका पार्टी वीडियो बैठ के देख रहा है क्या जो इतना परेशान है
लाइव स्ट्रीमिंग है तो
अभी क्या आप बहस कर रहे हैं अभी नोटिस कंप्लीट नहीं हुआ है
नहीं उसी लिए
28 days for orders will be deferred attachment to second appeal 167 of 2023.
डिफेक्ट तो सारा रिमूव हो गया डिफेक्ट सारा रिमूव हो गया खाली नोटिस होगा ना स्टेशन में in compliance all defects as pointed out by further report has been removed within 12 feet. SA number 167 of 2023. As per the office note, all defects have been removed. IA number 321 of 26 has been filed, seeking confirmation of delay of 159 days. the respondents in the electricity application for which requisites under speed post and ordinary process be filed within the period of 3 weeks from today pending. Since the counsel for the appellant is absent, let us not copy of this order to be issued to the counsel for the appellant to enter the conference. Post on 11th March. Awaiting service report, office to class, speed post.
Item 3, second appeal 234 of 2023.
Two earlier having filed this case law, 9372 of the 3 block, for leave to file appeal law.
Leave to file appeal.
My lord, the appellant's husband was party law in title suit, and during initial title suit he died law on 11/3 law.
11.
11/3/11.
During the pendency of title suit.
Title suit.
During the pendency.
Yes. Thereafter, Lord, the suit was decreed.
You were the plaintiff.
I
Your husband was the
respondent.
plaintiff.
Your respondent, defendant.
Your husband was the defendant.
Yes. Ordinary Lord, appellant's mother-in-law was a defendant number 7. After her death, the plaintiff's husband had been substituted as a defendant number 7, and who also died during pregnancy of title suit. Thereafter, suit was decreed, Lord. Against that judgment, two appeal have been filed by defendants.
By the suit was decreed.
Suit was
Two
decreed.
of the defendants they filed their appeal. So what happened?
All the out of total defendants, defendant number 7 was the vendor of the plaintiff law. While supporting the case, main issue was Lord in that suit was whether there was partition between the ancestor 3 recorded.
No, I don't know. Before the appellate authority also, it did not come that the husband, your husband has expired during the pendency of the suit.
He was made party, a dead person, Lord. And it
Notice
remained
was not issued.
notice.
Without issuing notice, the appeal was decided.
Yeah, Lord,
The appeal was decided without notice.
yes.
Yes,
Appeal was decided
the
against
first
a dead
appeal was
person.
decided without notice.
Whether notice was issued or not cancelled, what is the husband
Where
of
is
the
your death certificate? Where is the death certificate of your
death
husband?
certificate is page 10 of the IM law.
Page 10 of the IM.
Yes, IM number 9372.
Where is the appellate court's degree? Appellate court's degree. And where is the name of your husband? What is the name of your husband?
Ayodhya Tiwari.
Sorry?
Ayodhya Tiwari.
Where is his name?
Decreed at last one as a respondent number 5. In title appeal number 42 and 39 both are 42 में इनका नाम है सीरियल नंबर 5 इसको नंबर 5 और 39 में इसका नाम है इसको नंबर 30
आप इसमें ये वाला कौन सा वाला अपील है? दोनों में से कॉमन अपील फाइल करेंगे क्या लगता है?
कॉमन जजमेंट है कॉमन जजमेंट कॉमन इशू तो दोनों एक साथ जजमेंट है एक कॉमन डिग्री भी है तो उसमें दोनों को चैलेंज किया गया है
The learned counsel for the appellant has submitted that the husband of the appellant was party in the title suit and also in the first appellate court, but he had expired on 11/3/2011 during the pendency of the title suit itself. He was neither substituted in the title suit nor substituted at the first appellate stage, and therefore a petition has been filed seeking leave to file appeal through IA number 13144. Leave to file appeal through IA number 9372 of 2023, and he has also submitted that in the light of the aforesaid that a prayer has been made to another IA being IA number 13144 of 2025 seeking to ignore defect number 8, 20 and 23. सब इसी से रिलेटेड है?
सब इससे नहीं है 8 जो है उससे नहीं
8
नहीं
किससे
8 नहीं
रिलेटेड? 20 किससे रिलेटेड?
इसी से
और 8
है उसको हम कर दिया है मतलब पार्टी को कंप्लीट पार्टी पोजीशन 12 पेज 3 और 6 में आप सबका दे दिया हुआ है लेकिन बोलता है कि एपिलांट और प्रोफार्मा डिफरेंट नंबर 46 दे आर द heirs of the deceased appellant defendant appellant in court below blood and that line का बेटा लोग है उनको पार्टी नहीं था तो नीचे कोर्ट का पार्टी पोजीशन हम नहीं दे सकते हैं नीचे कोर्ट पार्टी नहीं था एपिलांट भी पार्टी नहीं था उसका
एपेलेट कोर्ट में पार्टी था?
नहीं था ना
तो ये ऐसा डिफेक्ट कैसे लगता है?
वही बोलता है कि ना आप उसको एक्सप्लेन कीजिए इसीलिए मतलब हम उसको पिटीशन फाइल किया और आइए पर एक्सप्लेन कीजिए आपको आप
Issue notice to the respondents on both the interlocutory application. IA number 9372 and also IA number 13144 of 2021. For which requisites we find to speed post on the respondents within a period of 2 weeks from today.
ज़्यादा टाइम दिया दूसरा पार्टी है
3 weeks from today. In the meantime, the counsel for the appellant is directed to file fresh party position नहीं वो आ जाएंगे तभी इसके बाद ठीक है post on 18th March.
Well, it judges your last fixed on 22nd February, 22nd starts the Sunday. Can it be fixed on in the month of March, not first week, not 24th?
22nd February.
Perhaps not I heard.
No, I've not fixed it on 22nd.
Sorry. Okay.
25th February.
But it should be listed in the month of March. This matters for your 24th period.
No.